Good afternoon to you.
Good afternoon.
I want to focus, just if it helps everyone, on two parts of your proof of evidence, paragraphs 7.9 and 7.10, which is page 58 of your statement.
Yeah, 7.8, 7.9.
7.9 and 7.10.
Oh, sorry, 7, 9, 10, yeah.
Okay, they're linked in a way because they are provisions that come under Section 58 of the Marine and Coastal Access Act that I want to talk about, and also the provisions that arise from the Marine Strategy Framework Directive and the regulations that follow on from that. So far as the water bodies of the UK are concerned, it's pursuant to those EU regulations that essentially in the early part, or about a decade ago, the country had to be divided up, or the coastal areas had to be designated as water bodies around the country had to be designated in different ways, including coastal bodies of water. Do you agree?
I don't know how that was divided up, so but I'm happy to take what you're saying to me.
Because what I'm trying to understand is your conclusions that you draw in paragraph 7.10, because you say that it's unclear what the Blue Marine's allegation is, and then you carry on to talk about it appears in essence that the concern of Blue Marine relates to biological diversity, whether the marine waters will achieve or maintain good environmental status. And then you go on to suggest that you've conducted a review of some sort. In light of the evidence of Dr. Jennings and my agreement with the EA's conclusions as to the impact of moribund biomass, I consider that the proposal would not breach the terms of the Marine Strategy Framework regulations. I'm trying to understand at the beginning, just so that we can all be clear, we understand each other, what it is in the Marine Strategy Framework regulations you looked at to decide whether or not there was a breach.
Well, it was more on the basis, the same as the EA, that if it passed the strict tests within the HABS regs, then it would pass the tests in relation to this. In terms of the water quality and moribund point, the EA had no concerns over that. And obviously Dr. Jennings' evidence is that there would be less fish killed than the Environment Agency had put together. So I've taken that. I've taken that as my lead.
Okay, so general principles, because you say that you consider, and this is your professional opinion, that the proposal would not breach the terms of the Marine Strategy Framework regulations. So did you actually look at those regulations?
Yes, I did, but only in a broad sense, because they're not something I deal with that often. And as I said, my starting point was if it passed the test of the regs, the habitat regs, and the Environment Agency's position and ours are aligned, but because that is a much stricter test, if it passed that, then it passed the other legislation. So that's where I've come from.
Right. So you saying you did apply those regulations to your decision making, and that's your professional view you've expressed?
Yes, in terms of the fact that I believe, all of my evidence is based on that there is no effect on integrity, and therefore the tests in the regulations are passed. And my position in the environment, or the appellant's position in the environment's position, is that if they are passed, then so are, the directive in relation to the marine environment. So that's how I've approached it. I've not gone down a separate assessment from that basis. It doesn't set that out in my proof.
No, the thing that I'm finding quite strange about that is that if you look at the marine strategy regulations, they're all about the setting up of the framework under which the coastal waters and other water body designations are to operate. It doesn't actually set out a test there at all.
No, but that's why if you pass the test of the habitat regulations, you're going to fit within that framework. That's what the Environment Agency think. That's what we think. So that's how I've approached it.
So where you say, I consider that the proposal would not breach the terms of the Marine Strategy Framework regulations, you really haven't looked at what those are, have you?
Only in broad terms. As I said, I was looking at whether there were more stringent tests associated with that, which, there aren't. And therefore, if you pass the HABS rates.
Okay.
So, no, I've not done a separate assessment in relation to that. The appellant and the Environment Agency are agreed on that position.
Well, let's examine the actual regulations that apply the test. You've come here as an environmental expert to give your opinion about the application of regulations to the facts.
Not quite. I've come in relation to the HABS rates because that is what I deal with. And the Environment Agency's position and our position, I mean, I could just keep repeating it, is that if we pass those tests, we pass the other tests.
It might help you if you have a look at on the computer CD 622, 6.22.
6.22. Bear with me.
Okay.
Yeah.
So
just download that.
If you go down to paragraph 7, we can actually see the regulations that you ought to have been looking at in my submission. Regulation 7 of the Water Framework Regulations 2017. Now, this is quite...
moment. Just bear with me a moment. It's just downloading.
Thank you.
And you'd like me to go to...
Paragraph 7, please.
7. Yeah.
Now, these are quite... the date of that's quite relevant because, of course, when the permit was originally granted, it was prior to these regulations being enforced, and these are new, by comparison to the permit, new regulations. And just so everyone's clear, it's SEI's position that the whole permit as granted would not pass these regulations, and that the derogation contained within these regulations is what ought to be applied. But let's have a look at the test, shall we? Regulation 3 of these regulations is that there is a duty on ministers and regulators, which is the Secretary of State, and obviously in relation to this matter, it's the inspector, and well, it's the Secretary of State who's called it in, who will make the final determination. And the obligation is, if you turn over the page, under Regulation 3, 2A, is to prevent the deterioration of surface water status, and B, to otherwise to support the achievement of the environmental objectives set for a body of water. Regulation 3.2 is without prejudice to the generality of paragraph 1. The Secretary of State must determine an authorization so as, in particular, to otherwise support the achievement of the environmental objectives set for a body of water. Okay, it's a mandatory duty.
Yes.
We agree with that.
Yes.
Maybe it's a matter for legal submission. Now, as far as this case is concerned and the facts of this case, we're dealing with a coastal body of water, the main one. We're dealing with a number that would be affected, but the main one, I think we could probably agree, is Bridgewater Bay, because that's where the abstraction site is, and that's where the return is, both within that body of water. Okay? And if you have a look at core document 8.32,
bear with me.
And it's 8.32, page 31, for those who may have.
Sorry, I'm still getting there. 8.32. Downloading that.
let me know when you've got there, and it's page 31 when you have it downloaded.
Sorry, it's just taking its time downloading it. Page 32.
31, sorry.
Sorry, no, that was my fault.
And we can, hopefully you can find, when you find it, you'll see at the top of the Appendix 2 table is the Bridgewater Bay water body. And water bodies are, have you got there?
Yeah, sorry, I'm just getting on to 29, 30, 31, Bridgewater Bay, yeah.
Water bodies are classified with statuses of high, good, moderate, or poor. Okay, and this site has an objective to reach good status by 2027. And we can see that from the point of view of 2019, the last dates that we have, it has failed to achieve that on the ecology status because it is moderate, so it's below the requirement. And it has failed on the chemical analysis. Okay. Now, coastal waters, the biological elements that are considered, and we could go back to the legal argument document or the legal submission document I showed you earlier, but let's just stay here for a moment because I can read it out. It's probably quicker for everyone. The coastal waters biological elements include the composition, abundance and biomass of phytoplankton and the composition and abundance of benthic invertebrate fauna. So we're looking at things like bioplankton and we're looking at the benthic invertebrate fauna, shrimps and things like that, that fish feed on. And this water body has only achieved moderate status in relation to that. So if we go back to the legal test, that the duty on the minister, this is regulation 3 again, without prejudice to the generality of paragraph 1, must determine an authorization so as in particular to either prevent the deterioration of the surface water status or otherwise support the achievement of the environmental objectives. Yes?
Yes.
Now, no one, it seems, in this case has done, we're going from, we're introducing into this area a power station that is going to draw 130 cubics of water per second. There's going to be, we've heard evidence in the course of the inquiry that that is the equivalent of, in the summer, all of the river contributors to the Severn. It's a vast amount of water that is going to be abstracted. And would you agree that an assessment of the effect of the abstraction on the invertebrates and the phytoplankton would be an important part of any consideration?
Well, I've got to look at it from the point of view of what the abstraction is actually doing and what it then puts back into the system. And as I said to you, the Environment Agency, even on its own figures, do not believe there is an effect on the water quality from the material, the biota material that goes back into Bridgewater Bay.
This is not the biota material I'm talking about.
No, I know.
I'm talking about the abstraction, the water quality requirements under the Environmental Water Framework Directive regulations and that body of water. So phytoplankton, that is going to be killed pretty much, isn't it, by this process? It'll go through the 5 millimeter mesh and be heated to the point where it dies.
But as I said to you, I've taken it from the Environment Agency. These are not, so I don't think I can help you in relation to this because it's not my expertise. If there were concerns about the Environment Agency's position, that this won't impact upon those regulations, then, as I say, the appellant has agreed with that approach and taken the lead from the Environment Agency's position. But I'm certainly not able to help you in that regard.
I see that the Tromans is...
Yeah, if I had a hand, I'd have put it up. The only way you can tell is I put my microphone on. There are two issues here, and Mr. Tromans, I'm sure one of these is the one you put your hand up for. The first is that your witness is saying that it's not an area that he's looked at is always before him. It's an area that the EA looked at and he's accepted their position. I'm just going to say quickly, and you can clarify this for me, I'm not exactly sure that that's true. Simply because Mr. Goodwin has dealt with this matter in his proof. And I don't have anyone else from the appellants here to respond to those points. Now, it may have been that Dr. Jennings might have been someone to do that. I did briefly ask about other species that could have been affected by the scheme, but I took him to Sprat. Maybe I should have taken him to phytoplankton. But Mr. Tromans, I'll more than happy for you to jump in with your position. And I think, Mr. Morris, we just have to make sure that within the bounds of what we know that this witness can deal with, we need to make them questions rather than statements.
I don't know whether it assists, but I'm not planning to go much further for those very reasons. I don't think it's going to help anyone to keep asking questions, but I suspect Mr. Tromans has another issue to raise.
Well, I was simply going to say, really, sir, that Mr. Morehouse seemed to be giving evidence and putting it to my witness, which appears nowhere in his client's evidence. It seems a very strange approach to start putting evidential points about effect on phytoplankton in your cross-examination when there's no evidence whatsoever to that effect in your own witness's case. That's my point, purely and simply.
Thank you. So in response to that, as you will have seen, I'm referring to documents within the core documents, so that it is evidence in front of the inquiry I'm inviting comment on. But I'm not planning to stay on this subject any further anyway, because I think the issues and the legal test that needs to be applied is perhaps more significant than the answers of Mr. Goodwin, as Mr. Tromans and yourself have said.
Yeah, I agree.
And another matter, Mr. Goodwin, and again, I'm probably going to, but there's only one issue that I'm going to invite your attention to, and that is your observation about the planning, the marine planning position, which is in paragraph 7.9. I think we agree. You said in your paragraph 7.9 that the marine plan is yet unadopted. The position, so far as the inspector is concerned, is that there is a draft marine plan in existence, isn't there? And we don't know, as with any draft marine plan, when that is going to, and what in its exact final form, when that's going to become a final and an approved plan. But it is potentially something which is a material consideration in making decisions in relation to marine planning. Would you agree with that, Mr. Goodwin? Not at the moment, potentially, but it may be.
I'd agree it's something to take into consideration, but it goes to the weight, doesn't it? If it's something that is in draft and hasn't been adopted, then we can't actually look to the future. That's no different from, I'm much more used to seeing lots of planning documents that may not be, maybe in the early stages of production. So for me, it's the weight that goes to something.
As an aside, I would, and this is more not a question to you, Mr. Goodwin, just so far as the other parties are concerned, there is, which we will put into submissions, legal submissions, DEFRA guidance to the MMO in relation to marine plans that we will make reference to. But just so far as the planning process, Mr. Goodwin, I think you've seen, and have you not, and some of the draft plan ideas or concepts, haven't you?
Yes.
One of them at the moment, SWNG1, which has been put into the SEI statement of case, so it's people have had access to it already, and if anyone wants to have a cross-reference to it, it's page 12. It's CD 6.4, and it's page 12. I don't know whether everyone is there.
I'm just getting there. It's just being downloaded.
It's in relation to your statement in your witness statement. However, I have reviewed the relevant policies and consider that the proposal complies with the marine plan. You've indicated that you don't. It's a draft plan, to be fair to your position, but you then go on and say you still think that this would be compliant with the draft marine plan. Let me know when you are there.
Yeah, I'm here. What
it's marine policy SWNG1.
Sorry, let me just write that down while I hunt.
This is CD 6.4.
Yeah, I'm in 6.4.
Page 12.
Page 12. Okay, I'm on page 12.
And I was directing your attention to one of the draft policy proposals, which is Marine Policy SWNG1. Proposals should deliver environmental net gain for marine or coastal natural capital assets and services. Proposals that may have significant adverse impacts on marine and coastal natural capital assets must demonstrate that they will, in order of preference, avoid, minimize, mitigate, and compensate for significant adverse impacts and deliver environmental net gain. So your statement that you've reviewed the relevant policies and consider that the proposal complies with the marine plan, obviously planning policies are indicators for inspectors and secretaries of state to follow. They're not binding, but which part of the marine policy do you think is not applicable or doesn't? I think you said that the proposal complies with.
Well, because as far as I'm concerned, the proposal, the plan or project that's on the table, has been designed in such a way as to avoid or minimise those effects, and also the mitigation of where we've placed the LVSE heads. So what I'm saying is we've gone through those stages. I mean, avoid, minimise, mitigate, compensate is a very standard thing for ecology. So insofar as it's a draft policy that seeks that you should be doing that, I believe that the proposal does that. That's what I meant by it was complying with it.
Do you agree with me that there is going to be some environmental harm caused by the operation of HPC?
Yes, and I agree with that in terms of, but I'm relating it back, of course, to the regs, that there may well be some harm that's generated, but of course that's not the test in relation to those regulations. But as I say, in terms of these being just a draft policy, I've looked through those as draft, and as I say, I felt it was appropriate, particularly in the light of the Environment Agency's position, but looking at things like that, that I'm happy that we wouldn't infringe those policies.
Yes. Subject to, for example, compensating for the harm that may be caused.
Well, as I say, it's a draft policy, so it's difficult to go into it, as far as I'm concerned, in that much detail. I mean, it's the same proposal in terms of the Environment Act that's coming through. It's not there yet, but people are talking about it. But at the end of the day, this is just draft. We don't know whether that changes in terms of that last provision on D. But as far as I'm concerned, the plan or project has avoided and minimised or mitigated, the harm in relation to the designated sites. So that's what I meant about it, as in terms of the generality of looking at those policies and not saying that we were out of step with them, but noting that they were unadopted and draft.
Thank you, Mr. Goodwin. I've no further questions for you.
Thank you.